My client is nervous that dad will drink alcohol and hang out in bars and things like that with the children. Again, the daughter, she's 2.5 years old, was wearing a diaper for a 5 or 6 year old. My client has concerns about his ability to co-parent or to parent 3 children all at the same time.
A 2.5-year-old girl named Breen went an entire overnight wearing a diaper 3 sizes too big for her body. That one detail, one wrong diaper, ended up at the center of a family court hearing that would decide whether her father ever got to put her to bed again. Case number 2020-6DM146, the marriage of Courtney and Adam Besd, filed in 2026. One child together, Breen,
in a situation where he cannot adequately parent this child. In the matter of the marriage of Courtney R.M. Bezdek and Adam T. Bezdek, case number 2026 DM 146. Starting with petitioner, would counsel announce appearances for the record, please?
Your Honor, if it please, petitioner Courtney Bezdek appears by and through counsel Kyler McMullen here in my office on Zoom.
Ashley A. Davis appearing on behalf of the respondent, Adam T. Bezdek, who is present in my conference room via Zoom.
Very well. This matter comes before the court at this time for...
who was about to turn 3. Adam also had shared residency of 2 older children from a prior relationship, Harper, age 10, and Emmett, age 12. When Courtney filed for divorce, the temporary parenting order she proposed gave Adam Mondays and Tuesdays from 5 to 7 in the evening, every other weekend, Friday through Sunday, but only during daylight hours. No overnights, not once. For his own toddler. That was the order already in place before this hearing started, and Adam's attorney, Ashley Davis, wanted the court to understand that it was built entirely on one side's request. Courtney's side, with no court finding that Adam was an unfit parent.
Well, Your Honor, the parties have one child, Brecken, who will be 3 next month. My client has shared residency of 2 other children, Harper, who's 10 and in the 4th grade, and Emmett, who is 12 and is in the 6th grade. And in the temporary order, Mrs. Bezdek gave my client Mondays and Tuesdays from 5 to 7, but she didn't give him overnights with their almost 3-year-old. She also gave him every other weekend from Friday 5 to 7, Saturday I think 9 to 7, and Sunday 9 to 7. There's no reason for my client not to have overnights with the 3-year-old. Again, during the marriage, my client tells me both parties took turns putting the child to bed. When I talked to Mr. McMullen about this and getting him up, he was like, well, sometimes he'd get home late. When the parties were having marital problems, she needed space, and so my client would try to stay out and leave her time because he was sleeping on the couch. Or, hey, occasionally some mornings she would take the child to daycare. And again, but she left the child with him for a weekend in March when she went to a bachelorette party. And I'm not disparaging her for doing that, but I don't see any reason why there would not be overnights for a almost 3-year-old child. Again, he has shared residency of his other 2 children. We are actually asking for a shared residency arrangement on a 2-2-5 schedule so that Brecken can stay on the same schedule with her half siblings that she's grown up with. And again, those are her siblings. That's going to be the most important relationship as they get older. And so we're asking for shared residency on a 2-2-5 schedule.
No investigation, no hearing, just a proposal from mom turned into a temporary order and now being defended as if it were settled law. Davis asked for a 2-2-5 shared custody schedule. 2 days with mom, 2 days with dad, 5 days with mom, then rotating. The same schedule Adam already had with Harper and Emmett. The argument was straightforward. Breen had grown up in a home with her older siblings. Separating her from that routine, from those relationships, served no one except the parent who controlled the schedule. Then Courtney's attorney, Kyler McMullen, laid out the case against overnights. And it wasn't nothing.
All right, Mr. McMullen, what's wrong with this proposed shared custody plan that would apparently treat each of the 2 parties as equals, at least during the pendency of this case?
Your Honor, Ms. Davis downplays significant concerns that my client has about dad's parenting ability, about dad's level to parent and supervise 3 children. He's not just asking for parenting time for 1 child overnight. That's a little bit different circumstances. Right now, he's got 2 kids, a 10 and a 12-year-old, and he's asking to add a 2.5-year-old to that mix for extended amount of parenting time overnights on Mondays, Tuesdays, and every other weekend. My client has significant concerns about his ability to handle that.
Text messages. Exhibit 14. 3:14 in the morning on a Thursday night. Adam texting Courtney from somewhere that wasn't home. Page 2, 3 in the morning again. A Wednesday pattern. Adam allegedly staying out all night at a friend's house, drinking, not coming home, then texting at 6 in the morning that he couldn't take Breen to daycare because he wasn't feeling well. The implication was clear.
He would sometimes come home late as an idea to give her space, Your Honor. If you would look at my petitioner's exhibit, it's my exhibit 14, Your Honor. There's a couple of text messages from dad to mom at, my first page of exhibit 14, Your Honor, is 3:14 in the morning on a Thursday evening. It's Friday morning, Thursday evening, that he's out late, hanging out with friends, doing whatever, not coming home. Sorry, Your Honor, the next page, again, is 3 o'clock in the morning. Woke up. I doesn't know what's going on with the child. Page 15, Your Honor, it's another couple examples that he goes out on Wednesday evenings over to friend's house and will stay out all night on Wednesdays. We'll drink alcohol, we'll hang out over there, and won't come home. We'll stay the night at the friend's house in the middle of the day, and we'll text my client at 1 o'clock in the morning that he's not going to be able to take the party's child to daycare, or that at 6 o'clock in the morning that he's not feeling well because he's hungover and was up until 3 o'clock in the morning drinking alcohol, Your Honor. Couple examples of that where he's coming home and asking her to take the child to daycare because he's not home, or is asking her to take the child to daycare and she's already done it. He texts at 7 o'clock in the morning and says, "Can you take our youngest child, who's 2.5 years old, to daycare for me because I'm not home on time to do that?" And she's already got the kid all ready to go and dropped off at daycare and on her way to work before he's even home from whatever he is doing. My client contends that she's nervous that type of behavior would continue if she's not around.
Hungover, unreachable, unavailable. And Courtney, already up, already had Breen dressed and dropped at daycare before Adam even got home. McMullen argued that Courtney had carried more than half the parenting load.
Extended periods of time from Friday to Sunday evening. My client is nervous that dad will drink alcohol and hang out in bars and things like that with the children. He's been doing that with the 10 and the 12-year-old on multiple instances, has no reason to think that he won't be doing that with the 2 or 3-year-old. Your Honor, the weekend in question, when my client gave dad some extra parenting time, she had an event to do on Friday, had the kid with her. The kid did not spend the night over there on Friday, as Ms. Davis's Ms. Davis's motion contends. Didn't spend the night on Friday. She did let him spend the night, or did let him have overnight parenting time on Saturday. When she went to pick the kid up on Sunday, dad was cagey with her, didn't want to agree on a time to do an exchange, even though it was an extra weekend that she granted, was cagey about those things, was cagey about communication. And when my client went to pick her up, again, the daughter, she's 2.5 years old, was wearing a diaper for 5 or 6-year-olds. It was way too big for her. And my client has concerns about his ability to co-parent or to parent 3 children all at the same time without her.
For all 3 children during the marriage, that a 2 and a half-year-old required a level of active, present supervision that Adam had not consistently demonstrated, that the one overnight Courtney voluntarily gave Adam, while she attended a bachelorette party, ended with Breen in an oversized diaper, and Adam being difficult and uncooperative at the exchange pickup. Wait, because it gets more complicated here.
No, Your Honor, and I will tell you, I tried to, again, I thought it was weird that my client didn't have overnights initially for an almost 3-year-old. And when I talked to Mr. McMullen, he was like, Well, maybe this is, in my opinion, about mother's control. Again, my client, when I talked to Mr. McMullen, he was like, well, he's not even sure, she's not even sure if the other two kids are there. My client's mother is here again, because I was like, had I known this was an issue, I would have had her sign an affidavit that yes, he still has the other two kids on Monday and Tuesday. This is about control for mom. And again, even though they had been sharing, I'm not going to go into, but when they talk about Wednesday nights, my client doesn't have the kids on Wednesday nights, and they were kind of doing an every other day thing with Brecken and kind of alternating. And again, I think it is ridiculous. They have this 3-year-old child. They have been parenting this child for 3 years together, but because mom is now, hey, we're filing for divorce, you only get 5 to 7 on these 2 days, and you can't even have overnights on the weekend. I think the court should do shared. Again, recommending domestic conciliation is a way to delay and delay. We need to get this kid on a schedule. I will tell you, Mr. McMullen was like, well, when she asked the 2.5-year-old if she saw her brother or sister, she'd be like, no, this is a 2.5-year-old. When you talk to a 2.5-year-old and you ask them what they did, nothing. I don't know. You can't believe what a 2.5-year-old says. Again, not that they just don't have that concept. So I'm asking for shared residency. I agree.
Davis fired back with a different read of the same facts. She told the court that on the Wednesday nights McMullen was describing, Adam did not have the children. They had already shifted to an informal, alternating arrangement with Breen. She pointed out that Courtney herself had left Breen with Adam for an entire weekend in March without incident, until the pickup, and she asked a pointed question that the court would not let go of. Did Courtney have to go through a step-up plan before she assumed primary custody of this child? The answer was no, she did not. But the proposal on the table required Adam to earn his way up to basic overnights with his own daughter, starting from a position where his wife had already locked in the advantage.
Adam would be living with his mother, would he not?
I believe so, Your Honor.
Isn't there a greater comfort level with a grandma in the house than there would be if he were on his own?
I believe so, but again, they're asking until a couple minutes ago to take full possession of that house. If we'd be okay with supervised visits, I believe. Again, that's kind of why I think your visit supervised by his parents while he's over there, while she's there. Make sure that grandma and grandpa are there during parenting time. Again, Your Honor, that's kind of why I thought that alternative dispute resolution or some kind of domestic conciliation where the parties could work on maybe a step-up plan, some kind of written plan that's good for the parties and good for their minor child, so that parties can kind of work together to work on something that works for everybody.
Did your client have to go through a step-up plan before she took primary custody of this child?
No, Your Honor, my client.
The other parent does, but you're saying the other parent does.
The judge paused on that. Right there, in open court, the judge asked Courtney's attorney directly whether it was fair that one parent required no vetting, while the other was being asked to prove fitness before earning overnight time with a child he had already been parenting.
I think these concerns about dad's behavior are legitimate. He has several parenting concerns that my client witnessed for long periods of time. My client has lived experience of not being able to share equally in responsibility for the party's child, especially one who's 2.5 years old, with dad. The one overnight that she decided to let him have during the pendency of this divorce did not go well. She returned with a diaper that didn't fit her, was cagey with exchanges and all of those types of things, Your Honor.
McMullen said he believed it was reasonable under the circumstances. The judge did not appear to agree. And here is where a fair-minded person has to sit with both sides for a moment, because the text messages are real. A parent texting at 3 in the morning that they cannot get their toddler to daycare because they were out drinking is a legitimate concern. That is not a manufactured complaint. If that pattern continued into Adam's solo parenting time, Breen would bear the cost of it. She is the vulnerable party in this case. She is the one who cannot advocate for herself, cannot call someone, cannot say she needs a different sized diaper. Whatever the adults are fighting about, she is the one living inside the outcome. But the other side of that is also real. Breen had a father who had been parenting her since birth. He had shared residency of 2 other children without documented incident. He was living temporarily with his mother, a grandmother who the judge himself noted was a natural stabilizing presence, and the temporary order Courtney proposed gave him less access to his toddler than many courts grant to parents with documented abuse histories.
But because she doesn't feel comfortable, she doesn't want to do it. And again, it's about control for her, and that's been the problem.
Thank you, counsel, for your respective arguments in this case. The court needs to make a decision today regarding a temporary parenting plan. The court will first note that the first parenting plan that was entered in this case was basically just based on one side suggestion as to what the proper parenting plan must be. The issue before the court today is Adam's recent behavior or his current status in a situation where he cannot adequately parent this child. This court will conclude at this point, no, he is quite capable, in the view of this court, of being able to care for a 2-year-old.
The judge ruled, no supervision required. The 2-5 shared custody schedule was
the court will adopt what has been referred to as a 2-2-5 shared custody plan as a temporary order in this case. However, the other suggestions regarding a holiday plan, this court specifically rejects. That we're too soon to be talking about holidays, with the possible exception of Father's Day. And it would be the intention of the court that father, of course, gets to see his child on Father's Day. I am presupposing that this case will be totally concluded one way or the other prior to any other meaningful late year holiday that might arise. So as far as the 2-2-5 plan, the court will adopt it. Supervision will not be required. Adam.
Adopted as a temporary order.
Yes, I can. You've made certain requests to the court today, and your attorney has argued your position well. I don't need you to rehash that. But essentially, you need to step up to the plate. You're asking to take on a lot more responsibility, a lot more. You're going to become responsible for a small child, as you know, gets into everything. Actually, I see the 12-year-old and the 10-year-old as assets in that situation rather than detriments. Anybody who can keep a watchful eye on a quickly moving 2.5-year-old, I think, is an asset to you. I'm also a little more comfortable with implementing this plan because you're staying with your mother. Grandmas usually are great caregivers and great substitute caregivers. So under her watchful eyes, I'm even more comfortable with the current parenting plan, which the court has ordered. But I think you've heard the concerns that the mother of this child has.
Yes, sir.
I will expect you to be that child's primary caregiver, not anybody else in the house. You need to work your schedule so that during your parenting times, that child is the priority. Yes, and not just leave the child there with someone else who can watch the little one. You need to take that primary responsibility, which I presuppose mother is already doing on her side. Yes, so sir. When it comes to going out or extended work or any other social activity that you may be inclined to be involved in, if you can't take your 2.5-year-old with you safely, then you need to change your behaviors and just do that kind of thing during her parenting time rather than yours.
Yes, sir.
This all seems like common sense, and it seems like it's really easy for the court to talk about, but in practice, it can be very, very difficult. But you've asked for this responsibility. The court would expect that you're going to step up to the plate and perform the duties that you're wanting the opportunity to perform.
Yes, sir.
So this is a temporary plan. If this doesn't work for whatever reason on your end that makes it unworkable, the court can always do something different. But we're going to give you an opportunity to prove that you are a shared residential custodian in reality.
Effective immediately. Then the judge did something less common. He asked Adam to unmute himself on the Zoom call and spoke to him directly. He told Adam plainly that he was asking for significant responsibility and that the court expected him to show up for it. He told Adam that his older children, Harper and Emmett, were not liabilities, they were assets, that a 10 and 12-year-old who could keep an eye on a fast, moving toddler was a resource, not a complication. He told Adam that if he could not bring Breen somewhere safely, the solution was to change his own plans, not to leave her with someone else in the house while he went out. It was firm, it was fair, and it left no room for Adam to claim he had not been warned. The spousal maintenance request, $500 a month from Courtney to Adam, was denied.
Having heard arguments of both parties regarding the issue of temporary spousal maintenance, the court will enter an order at this time denying the request for temporary spousal maintenance to be paid from the wife to the husband. This court believes that proper analysis of need and ability to pay needs to take place based on a post-June 24 analysis rather than today. This is a family clearly in transition. Their financial circumstances on each side are in transition. Until the parties get settled into what are going to be new residences for both parties, it does not seem prudent for this court to require one party to pay a spousal maintenance subsidy to the other. With that said, there could be, perhaps in the finalization of this case, as far as a final order in this case, a need to revisit the issue of spousal maintenance. The court makes no order in that regard. However, at this time, the court denies the request for.
The judge found that both parties were in too much financial transition to make that call responsibly. Adam was still living with his mother. Courtney was 2 days away from closing on a new house. The judge said the analysis needed to happen after June 24th, when both parties were settled into their new circumstances. The door was not closed permanently, just not opened yet. Child support was recalculated.
May 1st, Your Honor.
Okay, well, he'll owe child support for the first half of May. The shared custody schedule will take over as of the second half of May. So he'll owe one half of the original child support order issued in the case. For the record, announce that figure, Mr. McMullen, at least the monthly figure. Math would be pretty simple from there.
Give me just a second to find that number, Your Honor. I apologize.
Ms. Davis, I'm going to want that included in the order which stems from today's proceedings that you will draft. So,
Yes, Your Honor. I understand the ruling. He will pay one half of the original amount of child support, and then effective May 15th, the shared residency goes into effect.
Adam would owe one half of the original monthly support amount, $256.
Your Honor, the monthly child support in full payable by Dad was $512 per month. I believe one half of that is $256.
okay, that reconciles with the court's math. So if you'll include that in the order.
For the first half of May, from May 15th forward, the shared custody schedule would govern, and a new worksheet would be drafted to reflect that arrangement. Daycare costs would be split alternately, week by week, going forward. The judge closed the hearing with something that was not required of him legally, but clearly mattered to him personally.
Parental cooperation can take place. You're going to be co-parenting for a long time. So the sooner that there's a mutually cooperative relationship established, the better for this little one. Because what we really want to make sure we don't do is mess up this child in some way. So I think we probably got two good parents who want to be parents, and I have no reason to believe you're not going to be good parents. So good luck in that regard. Ms. Davis, anything else?
No, Your Honor. Thank you, Your Honor.
And if you'll get that order drafted with a new child support worksheet over to Mr. McMullen for his review and approval as soon as you can.
I will do that, Your Honor.
Mr. McMullen, anything further we need to address from your side?
He told both parents that they had a long road ahead of them as co-parents, that the sooner a cooperative relationship was established, the better it would be for Breen, that he believed both of them were capable of being good parents, that the court's job was to make sure this child did not get hurt by whatever the adults were working through between themselves. What makes this case difficult to walk away from is not the ruling. The ruling was reasonable. What stays with you is the structure that preceded it. A temporary order was put in place with no adversarial process, no findings of fact, no hearing, just a proposal from one party accepted as a starting point. And for weeks, that proposal functioned as law. Adam's access to his daughter was governed by a document that Courtney's attorney drafted. It took a motion, a Zoom hearing, 2 attorneys, and a judge's direct intervention to restore something close to equal footing. That is how temporary orders work in family court. They are designed to be fast, and fast, by definition, means incomplete. So the question worth sitting with is this: if the first temporary order had never been challenged, if Adam had accepted those 5 to 7 evening windows and walked away, would Breen have grown up thinking her father chose to be mostly absent? And who would have been responsible for that?